Good afternoon. So I'm Jessica Price, and I have been an attorney with the American Civil Liberties Union of Southern California for 3 years. And I expressed when I started a strong interest in First Amendment freedoms, which includes freedom of speech and freedom of religion. I was going to the LA County Jail on a regular basis because we have a lawsuit involving inmates with mobility impairments, inmates who need access to a wheelchair or walker or crutches. So I was visiting the jail at least once a week in that case. During my visits, I also heard from Muslim inmates who expressed a strong desire to get access to halal meals. And this is when I first started at the jail. They told me that they lived with or they saw Jewish inmates who had access to kosher meals, but they did not have access to halal meals. Some of them had requested the kosher meals at least, and many of them were unable to get any sort of diet accommodations. Some of them were told you have to speak to the dietitian, and then the dietitian said you have to speak to the chaplain, and then the chaplain said you have to speak to a dietitian. So they just encountered a brick wall when it came to getting accommodations for their meals. So we drafted a strongly worded letter with a focus on the halal meals issue. And as far as the legal background goes, traditionally, under the First Amendment, there is a right to freedom of exercise of religion. And if a government official sought to impose restrictions on that exercise of religion, they could if that restriction is rationally related to a legitimate penological interest. So in the jail, if they said, we have a financial reason not to order halal meals, that might have passed muster. However, if as in this circumstance, they were accommodating the religious diet of one group of inmates, that undermines the justification for denying access to that the same sort of accommodation for another group of inmates. In 2000, Congress passed the Religious Land Use and Institutionalized Persons Act. It's called RLUIPA. And RLUIPA is a very powerful tool to protect the religious freedoms of people who are incarcerated. Under RLUIPA, it's strict scrutiny. And strict scrutiny means that the government cannot impose a substantial burden on someone's religious exercise unless it has a compelling interest. So that is an extraordinarily difficult standard to meet. Security is a compelling interest. The courts have said that jail security is a compelling interest. But in 2007, in the Ninth Circuit, they said you can't just say security and justify any sort of restriction. You have to have a specific reason, a specific security concern as to why you're denying inmates access to an accommodation. So we wrote a strongly worded letter with a focus on the halal meals. We also included two other important issues. One was access to religious items, such as prayer beads, and the other one was access to group worship. Inmates complained after Ramadan, that first year that I started, that either they had no access to observe Ramadan, or some of them, in order to be able to go to Ramadan, they were subject to a strip search, and they were subjected to offensive, abusive words by jail deputies once they identified themselves as Muslim. So we included these incidents in our letter, and we were able to set up a meeting with jail officials. And I went with my supervisor, Peter Eliasberg, who's been doing this for far longer than I have, and Mr. Shakil Syed agreed to join us as well to express these concerns. And at the meeting, we had a very productive conversation about how the strip searches as a condition of attending religious services could not continue. Jail officials did agree that they would be ordering halal meals within 3 months of that meeting, and they did agree that inmates should have access to group prayer, absent security concerns. So that was thank you. That was 2 years ago. In the meantime, I'd been working with people in state prisons, and that started because some of the men that I had met in the county jail had moved on to the state prison. And so I heard from inmates in North Kern State Prison that men who wanted to wear the kufi cap were not allowed to wear the kufi cap at all. They weren't allowed to congregate to pray. And I wasn't sure whether that was okay, because they might say that you could hide a weapon under the kufi cap. So I looked into it, and it turned out they did allow people in North Kern State Prison to wear baseball caps, but they prohibited the use of the kufi. So we wrote a strongly worded letter about the prohibition on the use of the kufi and the access to congregational prayer. And very swiftly they responded, and these men wrote to me as soon as the changes were implemented that they were allowed to wear the kufi with some color restrictions, and they were allowed to attend religious services on a weekly basis. So North Kern State Prison was very responsive, very quick to respond, and we used the same standard, which is RLUIPA. It is a strong protection of people's religious freedoms. There is no compelling government interest in prohibiting people from wearing the kufi if at the same time they allow people to wear baseball caps. So that was some very quick progress we had in North Kern State Prison. Before I started at the ACLU, they had a lawsuit called Khatib on behalf of a woman who was in a jail, who went to court and who was ordered to remove her headscarf and was arrested for refusing to remove her headscarf. And that became a very complicated issue about whether a jail holding facility or a court holding facility is subject to the same standards, RLUIPA, and the court eventually held that it was. Very recently, we worked with a client at Tehachapi State Prison, and she went to visit her son in prison. And when she went to visit, they told her she could not enter with her headscarf. She said, "I have to have my headscarf for religious reasons." They said, "We don't believe you. Bring a letter as proof that you need to wear it, but if you want to see him today, you have to remove it." And she and her husband had driven for hours to visit her son. It was the first time in a while, so she complied, and she removed it, and there were over 100 people in the visiting area. And she was very ashamed to have to go in and see her son like that, and she didn't get the chance to put it back on until she left the prison. We wrote a strongly worded letter in response to that. That is a difficult issue, and it's interesting because a RLUIPA is the Religious Land Use and Institutionalized Persons Act, meaning it applies for religious property and it applies to inmates. And the reason is because if the government is restricting people who are incarcerated from exercising their religion, Congress felt that we need to be particularly vigilant in that circumstance. In this circumstance, this woman is not an institutionalized person. So RLUIPA doesn't necessarily apply. And so I found it very difficult to find that because you're not incarcerated, your freedom of religion might be less than someone who is incarcerated, so that her as a visitor would have less protection than the son that she was visiting. So instead, we wrote a strongly worded letter about the First Amendment, the no rational basis to require her to remove the headscarf, and California state policy. California state policy says if you require someone to remove the headscarf, it has to be with a female deputy in a private room. And again, the state prison official's attorney was very responsive, and just yesterday they agreed, because I told her it was urgent because she was visiting her son again today. Just yesterday they agreed she will no longer be required to remove her headscarf. Thank you. And they will provide something in writing so that she can show that if anyone gives her a hard time. The thing is, it shouldn't have to come to that. She should have been able to see her son in the first place. The deputy should not have questioned that that was a part of her religious beliefs. Even though she brought a paper the second time she visited, they still did not allow her in. So it shouldn't have to come to that, and so there's a very strong need for religious advocacy and making sure that people who work within the correctional facilities are aware of different religious requirements and the need to respect those absent very serious, compelling government concerns. So what we continue to work on is in the jail, the LA County Jail, access to congregational prayer. We are encountering inmates who are medium security, who are not allowed to gather to pray. And there was a lawsuit in 2007 in the Ninth Circuit where inmates wanted to hold their own congregational prayer. And the prison facility said, we have a compelling interest a security interest in keeping them from going. And these were maximum security inmates. And the Ninth Circuit rejected that and said, you can't just say we have a compelling interest. You have to show a specific reason why a particular person will jeopardize the prison's security if you allow them to attend their religious services. So we continue to work on that issue. For me, the hearing from the clients, I continue to talk to them about the importance of getting them this access while they're there. The majority of them have not been convicted of anything. They're waiting for their opportunity to be heard in court. And so in the meantime, it's really important, I think, for everyone to be aware that this is happening, and for people who are experiencing this to be aware of their rights and the opportunity to request access to see a chaplain or to gather to pray does exist, should exist, and it shouldn't have to come to a lawsuit or some other serious fight in order to make sure that people are able to observe the requirements of their faith. That's everything. Thank you.